Hello, everyone, and welcome to Uncivil Law. For today's case, we have a case dealing with a traffic stop. This person was driving drunk down the road. They were pulled over, and then a dog was sick on them, and some damages caused as a result. So, we're going to read a little bit more about the facts of the case and what caused this to happen. This is the Sixth Circuit Court of Appeals out of the state of Michigan in the case of Keaton Ashford versus Michael Raby. And so, we're going to learn a little bit about this traffic stop and whether or not this dog being used was okay. So, let's get started with this. Keaton Ashford was driving on the highway after having too much to drink. A police officer noticed him speeding at over 100 miles an hour, so that's pretty good work, right? And changing lanes without a turn signal. The officer sped up to follow and soon turned on his lights to indicate that Ashford should pull over. This sent Ashford into a panic attack. Instead of pulling over, he decided to drive somewhere he felt more comfortable, a Walgreens by his home. Of course, the officer knew nothing about what Ashford was feeling. He knew only what he could see from his perspective. Someone had been driving erratically at over 100 miles an hour and now was refusing to pull over. The officer tailed Ashford for 2 minutes while radioing in the details of the chase. Eventually, two backup cruisers arrived. The three police cars then surrounded Ashford and forced him to stop. At that point, two officers got out of their cars and told Ashford to show his hands. He complied, thrusting his hands out the windows. The officers then told Ashford twice to turn his engine off. He did not comply, instead further thrusting his hands out the window. So this is always a problem with contradictory commands with the police. You can't do both at the same time. Show me your hands and turn off the car. How am I supposed to do both? If I reach back in the car, someone's going to shoot me. So it's like, not so great. So what am I supposed to do here, right? That's when Officer Raby and his trained dog Ruger arrived on the scene. From then on, Raby took the leading role in the officers' interactions with Ashford. While the other officers told Ashford to keep his hands up, Raby slowly approached the door and tried to open it. Finding it locked, Raby told Ashford to unlock it, then reached through the window, unlocked it himself, and pulled it open. With the doors open, officers told him to step out of the vehicle. But he didn't come out. Why not? Because the SUV was still in drive, and his foot on the brake was the only thing stopping it from lurching forward into the police cruiser. When you're stopping for the police, you probably should just put your car in park, to solve these kinds of problems, but that's not what they did. So, yeah, might be because alcohol. Ashford was afraid that if it happened, the officers would think he was using his vehicle as a weapon and shoot him, right? So if he tried to get out of the car, his foot would get off the brake. Then his car would move. Then he'd think he's using the weapon, so they might shoot him. So he's thinking to himself, I can't do that. Fair enough. Unfortunately, Ashford also didn't think he could turn his vehicle off either. Why? Because that would have required him to retract his hands into the passenger compartment. Right. I can't do both at the same time. I can't show you my hands and turn my car off. And he was terrified that if he did that, the officers would think he was reaching for a weapon to shoot him. So yeah, I'm in this position where I can't do anything. I can't step out of the car because if I do, my foot will go off the brake and the car will move and they'll shoot me. I can't put my hands back in the car to turn off the car because if I do, they'll think I'm reaching for a weapon and they'll shoot me. So I'm in this position where I can't do anything. I'm not sure what I would do in this position. This sounds like the best course of action. I got nothing better. Ashford attempted to try to explain this dilemma while intoxicated, which I'm sure was really interesting too. He had an idea. Although he was unwilling to leave, the officers were free to reach into it and put it in park or shut it down themselves, at which point he got out. But it's unclear whether they heard the suggestion over the noise. Even if they did, they weren't interested. They just kept telling Ashford to step out of the car. They also warned him if he didn't, Raby would send the dog to apprehend him. After 20 seconds of refusal to leave the vehicle and one final warning about the dog, they commanded the dog to attack. The dog made two lunges but failed to lock onto the defendant in either time. After the second attempt, Raby, the officer, stepped in to help, grabbing the left arm and lowering it for the dog to bite. Nice. Raby and Ruger then pulled him out of the driver's seat and onto the road, where the officers completed the arrest. Afterwards, the officer took him to the hospital. He was treated for 3 puncture wounds and several more superficial injuries to his arm. I'm not sure, again, what I'd do if I were the defendant in this situation. Not a lot of bad options. He sued for violation under 1983 for the excessive force by the dog. What are the standards that apply to the seizure by dog? Ashford faces an uphill battle. To be constitutional under the Fourth Amendment, the use of force need not only be reasonable, but because reasonable does not require vindication by hindsight, nor does it mean the best technique available. In police work, officers usually face a range of acceptable options, not a single rigid right answer. The reasonable standard thus contains a built-in measure of deference to the officer's on-the-spot judgment. In damages issues like this one, the built-in deference becomes a double deference. That's because the standard constitutional protections the officer's reasonable factual mistakes, and qualified immunity protects him where he reasonably misjudged the legal standard. So he has double immunity. He has double immunity on the facts, and he has immunity on the law. So he's all kinds of immunity. QI strikes again. Thus, even if Raby's force was unreasonable, he still can't recover unless unreasonableness was clearly established. That's a tough standard. How tough? Well, Ashford must show that the then existing precedent put the illegality of the conduct beyond debate. The law must make it so clear that every reasonable officer would have recognized the force was excessive, not just in the abstract, but in the precise situation following. The qualified immunity standard is once again pretty high, as we see here. So, can Ashford show he violated clearly established rights? He cannot. To see why not, consider three questions. Was it reasonable to use force to remove? Was it reasonable to deploy the dog? And finally, did they reasonably manage the dog during the seizure? The decision to use force to remove him from the car was reasonable. Think about it from the officer's perspective. Ashford had just led law enforcement on a 2.5-minute highway chase and then was refusing to get out of his vehicle. Surely a reasonable officer would believe it appropriate to remove the defendant from the vehicle at this point. Indeed, the court has recognized that and approved the seizure of a runaway driver under similar circumstances. It is true that Ashford had his hands up and was not making any aggressive moves, but this does not change two critical facts. The officers could not control the scene with Ashford in the vehicle, and Ashford was refusing to remove the vehicle. If he's unwilling to budge, the officer had little choice to remove him. It is true that Ashford had a reason for not wanting to move. The vehicle is in drive and he's unable to turn it off while also keeping his hands up. He's faced with an impossibility. Under this circumstance, his reluctance is understandable, but it doesn't matter because we also understand why inviting the officers to park the vehicle seemed like the best idea, but we must consider this from the officer's perspective. So he behaved reasonably, but we don't care. Great. Consider the steps involved in the proposal. To reach the gear shift and keys, an officer would have to lean in over Ashford or climb into the vehicle on the passenger side. Next, for the officer to move the gear, he would have to keep his foot on the brake, because you do have to keep your foot on the brake in order to move the gear. That's true. Now consider the risks involved. What if Ashford attacked the officer when he came within range? Maybe to seize the weapon or use him as a human shield. What if someone else was in the back of the SUV and that person attacked the officer? Or what if Ashford, seeing a last-ditch opportunity to escape, took his foot off the brake and floored the gas instead? The resulting movement would jolt the officer entering the vehicle, taking the officers outside, and endanger everyone. In short, Ashford's idea only made sense if they trusted him. But what about the use of the dog? Granting it was reasonable to seize Ashford, was it reasonable to use a police dog? Or was sending out an 80-pound Dutch Shepherd to drag him too disproportionate? In answering these questions, it's helpful to ask, what is the alternative? To be sure, showing a potentially gentler alternative is not enough by itself to make a use of force unreasonable. But that doesn't mean the absence of superior alternatives is irrelevant. Common sense says a court should not condemn an officer's actions without some idea of what they could do instead. Here, the defendant has no suggestion other than the impractical one for how they should have removed him from the vehicle. The simplest dog-free alternative would have been to use one or more officers to pull him from the vehicle, exactly what happened minus the dog. While this would have spared Ashford some painful bites, it would have placed the officers in greater risk. After all, grabbing Ashford meant attaching oneself, at least briefly, to the still running SUV. One will take note here that the fact that they were risking the dog's health is apparently not a concern to the police. So there's that. As it was put in the deposition, all Ashford had to do was step on the gas, and you have a 6,000-pound vehicle that you're next to and possibly getting drugged by. Given the risk, it was reasonable to entrust the first stage of the seizure to the dog. At the very least, the choice to deploy the dog was not plainly incompetent and did not violate clearly established law. Was the degree of force reasonable, however? Finally, Ashford argues that the unreasonable prolonged use of force, allowing him to keep biting him after he was subdued. This argument requires a closer look at what happened just after Ashford was pulled from the vehicle. The videos belie the suggested timing, as well as the suggestion that they gave the dog free rein. The video shows, once Ashford is out of the vehicle, the police officer devotes his attention to controlling the dog while other officers focus on surrounding the suspect. The officer gives Ruger the release command within a couple seconds of the officer securing the right arm, about 4 to 5 seconds after pulling from the vehicle. They stop screaming within a second or two after that, showing that it was obeyed. All in all, the footage shows that the handling of the dog during the seizure was reasonable and professional. At the most, one could argue that the dog could have been called off a second or two sooner, but that kind of fine slice judgment, called amidst tense, uncertain, and rapidly evolving circumstances, just is not the stuff of Fourth Amendment violations. Qualified immunity for dog bite affirmed. In the end, nothing about the use of the dog to seize violated a clearly established right. Therefore, qualified immunity we affirm. So that is the end of our coverage of the case of Keystone Ashford versus Michael Raby. In this case, we learned that there was a driver proceeding 100 miles an hour down the highway while drunk, and he was pulled over, but he couldn't obey all the commands at the same time. He showed his hands, but then he couldn't turn off the car because he was showing his hands. He couldn't get out of the car because his foot was on the brake. And so the police sicked a dog on him. But the court says, this is okay, this is unreasonable, it isn't unjust, and if it wasn't clearly established, so you're out of luck. So that is the end of the coverage of this case. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.